Again, if they had not obtained some form of intellectual property to protect this, as soon as they start marketing it, then their competitors such as Walmart and other low-cost manufacturers will come on and offer the same product for less. Here's a second idea you might have. This is a 𝗕𝘀𝗀𝗶𝗴𝗵𝘁𝘀. You can see this is a small cat-like sort of rubberized product. It has a lot of features to it. The tail, as you can see in the upper right picture, can be used to open bottle caps or fish out the cotton from your pill bottles. The head here is a pry in the lower right picture, you can see, to help, again, generally older people help open their pill bottles. And you can put the pills for the day that you need to take on the back of the cat. You've got a pill splitter here in the bottom of the cat. And then the cat is squeezable so that you can use it as a gripper when you need to open a bottle as well. But again, if you don't have some form of intellectual property to protect it, then you're going to face competition very quickly, and you may not be able to earn any sort of return on your great idea. Certainly not become as rich as Bill Gates and Jeff Bezos and some of those other individuals. So you need intellectual property to protect your idea, prevent others from copying it, so that you can derive the economic benefits from it. In the United States and in most countries around the world, we have 4 types of statutory intellectual property. We have the patent regime, we have the copyright regime. Both of those in the United States have been around almost since the outset of the country. The very first Continental Congress in 1790 enacted the first U.S. patent and the first U.S. Copyright Act. Trademark has typically been a state law issue, but currently we also have a concurrent federal regime for protecting trademarks. And then trade secrets is our 4th federal regime. And in the most recent at the federal level, again, largely a state law issue for many years. In the United States, we have dual systems of law. Each individual state often has its own rules or laws on a given subject. And then sometimes you have federal law on those issues as well. Patent and copyright are exclusively federal regimes. Trademark and trade secret have overlapping, largely duplicative state and federal regimes. So we're going to talk about each of those 4 at least a little bit. And now the basic justifications we offer for having intellectual property. Why do we protect your idea? Well, it's not just so you can get rich, so that's a good thing from your perspective. But patent and copyright, the notion is we need incentives. We need this protection so that the inventor or the author, patent and copyright, can recover their investment in either inventing or discovering something, or writing a book, or writing a play, or creating a movie. And so we give them a limited time monopoly where they're the only one that can sell their patented invention or their copyrighted work of authorship. And so that allows them to charge a slightly higher price for those products in the marketplace. And that means they can recoup their authorship or invention costs, and so have a worthwhile reason to go into these fields. So it's not just to give them money, it's because we worry that if we don't provide protection, the copying competitor will come along, and so people won't bother to really invest resources in either inventing new discoveries or authoring new works of authorship. Now, trademark has a different purpose. Here, the purpose is really promoting competition, enabling you as a consumer when you go in the grocery store to readily find the product you're looking for. In the United States, that might be a Coca-Cola. It might be a certain brand of milk that you really like, but it enables you to find the one you're looking for without being misled or tricked into buying some look-alike product when you thought it was the real thing you were getting, but you're not. So let's work through the 4 statutory areas. There are substantive requirements, there are procedural requirements. The patent regime protects inventions and discoveries. So it's subject matter in the United States and pretty much elsewhere around the world, protects new machines, new manufacturers, new industrial processes, or a new composition of matter. And so there are a lot of different things you might patent. We'll look at some examples in just a minute. It has both substantive and procedural prerequisites. The substantive prerequisites, if you want a patent on something, you have to show us that it's novel, that we don't already have it. We're not going to give you patent on the compound salt, though that would be a very profitable monopoly. But we already have salt, so we're not going to give you a patent on it. You also have to show us it's not only new, but that it's, in the United States, we call this non-obvious, a non-trivial, a significant advance over what we call the prior art. The prior art's a sort of catch-all term for those things we already have, like salt. And so it has to be not only new, but non-obvious advance of the prior art. Most of the rest of the world calls as a second requirement the invention requirement. But here in the US, we call it non-obviousness. And then third, for utility patents, you have to show us that it's useful. Must have some use. Now, it doesn't have to be a great use, doesn't have to be a better way of accomplishing a given result, but it has to do something. In addition to these substantive requirements, the Patent Act in the United States and around the world also require an inventor to timely file a proper patent application. In most of the world, this is before any sort of public disclosure of your invention. Here in the US, we have a 1-year sort of gap. We'll give the inventor where they can disclose it or sell it, and then file the proper patent application within a year. Most of the rest of the world doesn't give the inventor that leeway. Once you've filed your patent application, it goes through an examination process in your patent office for your home country. You can also get patent protection around the world through the Patent Cooperation Treaty. But once you have your patent in hand, if you can get through that examination process, it gives you as the patent holder the exclusive right to make, use, sell, or offer to sell the patented invention. And it lasts 20 years from filing. Okay, so as I said, there are a lot of things in technology that have been patented over the years, from very significant advances like Edison patenting the light bulb or Bell patenting the telephone. There are also patents on relatively trivial or non-significant technical advances such as new squirt guns. So it covers a range of products. And again, as long as you satisfy the prerequisites, you're good. So one of the key issues here, the principal hurdle to getting a patent, is whether you've got a significant enough advance over the prior art. And so in the United States, this again is governed by the non-obviousness doctrine. Around the world, most of the rest of the world call this the invention requirement. But again, it has to be a non-trivial advance, right? We're giving you a monopoly. You have to show that there's some reason to give you a monopoly, that if we didn't give you this patent, you would not have bothered to invent your discovery at all. And so here's an example that was litigated all the way to the Supreme Court of the United States a few years ago, about 15 years ago now. So as we made the transition from old carburetor-driven analog systems for fuel injection, carburetors, things of that sort in the United States, with new fuel requirements, fuel efficiency requirements, emissions requirements, we switched largely from those analog control systems to digital. Electronic fuel injection and digital control systems all the way around. So carburetors went the way of the horse-drawn carriage, as it were. And so in the old analog systems, when you pushed on your gas pedal, there was actually a cable that pulled a butterfly valve on the carburetor that increased the level or the amount of fuel air and mixture that was being injected into the cylinders for combustion. With electronic fuel injection, we don't need that, right? We need to tell how hard you're pushing down on the gas pedal to get a sense of whether you're trying to keep the speed stable, steady, accelerate quickly, accelerate slowly, or slow down. So we need to know how hard you're pushing down on the pedal. And of course, we could replace that pedal with just a digital sensor on the steering wheel. We haven't so far. So this goes to show you that we're creatures of habit, I suppose. But instead of an analog cable just running physically connecting that pedal to the butterfly valve, we needed to replace that analog cable with a digital sensor that converted the pressure on the pedal into zeros and ones, and then transmitted the zeros and ones, though it didn't have to be in any sort of tension, just along a wire or cable, to the electronic control systems for the electronic fuel injection. So someone was the first to come up with the new pedal assembly that had the digital sensor and could send an appropriate signal to the EFI system. Should you be able to get a patent on that? Right? Is that a non-trivial advance? Is that an advance in the art that we won't get without giving you the benefit of a patent and its monopoly? And the US Supreme Court said, no, it's not non-obvious. It is obvious and therefore not patentable. With the fuel efficiency and the emissions standards the government was imposing, we were going to have to go to digital control systems anyhow. And so this is not really a difficult technical problem. How do you get a digital signal from a gas pedal? And so it does not merit, it's not sufficient advance to receive a patent. And so the court said no patent here. Now there is a downside of patents, which is when you come up with your great new idea, and this is again a squirt gun, a toy, it received its own patent. But because patents are make, use, or sell, even if you do your own work, you can still be an infringer of someone else's patent. And so the manufacturer of the Super Soaker, which became a very popular toy here in the United States, sold millions of dollars worth, was sued by an earlier squirt gun manufacturer who had first developed a sort of idea of a pump action for the squirt gun. And he held a patent. And unlike our other areas of intellectual property, copyright and trademark in particular, where we look at your book versus my book, or we look at your trademark Coca-Cola versus my trademark Pepsi-Cola, and we ask if they're too similar in different ways, well, different ways in copyright and trademark, but we're looking at what you're actually selling out there in the marketplace. In patent, when you file that patent application, you have to include claims that describe exactly what it is you think you've invented. And so here was the patent claim at issue that the earlier squirt gun manufacturer was saying had been infringed by the manufacturer of the Super Soaker. So it's a toy simulating a pistol, and this is known as the preamble in patent law. Comprising is our transitional phrase, and then you have to have, in the US and most other countries, right, a description of the elements that make up the patented invention. You have to include everything that's necessary for the invention to work, and at least one thing that differentiates you from the prior art. So when we do validity, are you novel, non-obvious, we don't compare the product you're selling to what's being sold out there in the world before you. We compare what you've written in your claim right here to the prior art. And when we do infringement, again, we don't look at your squirt gun versus my squirt gun as we might in copyright or trademark. Instead, we look at your patent claim, the language, the words you use, and we compare that to my toy in this particular case. And so you can see here that we have a cylinder disposed axially in said tank and a check valve. And here's our piston mounted in said cylinder for manual reciprocation. So if you like the sort of technical drafting, you should be a patent agent or a patent attorney. And this is our pump. So what we look for is we see if this language, each of these elements, and you've got the case and the water tank and the air pump and the discharge tube, the outlet nozzle. So we put in brackets sort of each of the separate elements, it's sometimes called. We have to see if each of those is literally present in the defendant, is the person who was sued, the popular squirt gun manufacturer was sued. Of course, this squirt gun was not popular at all. But once you have your patent, you can sue the popular guy and say, hey, they copied my idea. So what do you think, right? Is each of these elements, each of these words present in this squirt gun? If so, there's infringement, and the owner of the Super Soaker is going to have to pay damages and may have to negotiate a license with the earlier patent holder and squirt gun manufacturer. And the case actually turns on the very precise language used in the patent claim. If you'll look here at the third line, it says a tank in the barrel for a liquid. And that was entirely typical of squirt guns in the prior art. You didn't put the tank on top, rather the body of the squirt gun itself was the tank. And so saying the tank was in the barrel just really meant the body of the gun was the tank itself. Now, does the Super Soaker have a tank in the barrel? No, it does not. So there is no literal infringement. And we also have a doctrine in the US called Doctrine of Equivalence, where we'll give you a little bit more beyond just the words. But really, putting the tank above the gun really changed and made the guns, as a squirt gun, far more effective. By moving the tank out of the barrel, the tank was no longer confined to the volume of the gun itself. You could have a very large tank, as we did here. And that gave you two things that made it more effective as a squirt gun. Gave you more volume of water before you had to reload your squirt gun. And because it was a larger volume, it gave you more ability to compress and get a higher pressure on the tank of water. Now, I know you may have learned in engineering school that water is incompressible. Take that with a grain of salt. Of course, it's only relatively incompressible. If you put water near a black hole, it will compress. And in our world, even in our world, water often has dissolved gas in it, and that gas will definitely compress. But the larger volume, again, with the larger volume of dissolved gas, meant that you could get a much higher pressure on your tank of water. And so when you pulled the trigger and squirt the gun, it doesn't just go 2 or 3 or 4 feet or a couple of meters. And you can get in some of the guns that Super Soaker developed, you could get a stream that would go 10, 15 meters. I mean, it would just go very far because you could get a lot of pressure with a bigger tank. And so it was held not to be an infringement of the earlier squirt gun. But again, this is a risk with patents, that you'll offer a new product on the market, and then someone who came up with something similar, even though you never saw it, you never saw their patent, you can still be sued for patent infringement. Okay. So the second statutory area, I see there are a couple of questions. I guess I'll take those at the end as we have time. So copyright, again, long-time federal statute in the United States since 1790. Where patent protects machines and manufacturers, copyright protects works of authorship, books, movies, songs, things of that sort. It's prerequisites. There are no procedural prerequisites for receiving copyright protection. All you have to do is do your own work. It has to be original. That's the principal substantive prerequisite. And it has to be fixed. Now, that does not mean you've taken your dog to the vet to get it fixed. That just means it's recorded in some more or less permanent fashion. Ice sculpture is fine. Notes that you've taken in your notebook or on your computer in the RAM memory, that's fine. If you stored it to the hard drive, that's certainly fine. So we're looking at recorded authorship. Now, originality is different than novelty. It means you did your own work and you didn't copy from someone else, even if your work ends up looking very similar to someone else's. So you're both doing sort of maps of a given city, and what do you know? The maps look very similar. Of course they do, because they're supposed to be accurate, and so the roads are where they are. Each person gets their own copyright. It's not a novelty requirement where you have to show that it's new and a substantial advance over the prior art. Just has to be your own work. Now, the general scope of copyright, unlike patent, which encompasses make, use, or sell, and so even if someone's an independent inventor, the Super Soaker guy had never seen the earlier squirt gun or the patent for it, didn't matter. Independent creation's not a defense in patent law, but it is in copyright. So copyright only protects against copying. So as long as you do your own work, you're not an infringer, and indeed, you're probably entitled to your own copy. And it only protects expression, not the underlying ideas in the work. In the United States, the duration varies a little bit around the world, but the general trend has been towards longer terms. We started with 14 years plus 14 years. In the US, now it's life plus 70 years, the life of the author plus 70 years. If it's Disney or a corporate author, then you get 95 years from the date of publication, or 120 years if it's not published. But those are just very long terms, much longer than our 20-year copyright term. Okay, so here are some examples of things you can copyright. Books, Charles Dickens, Tale of Two Cities. Of course, he wrote in the 19th century. At that time, the US copyright did not protect the works of foreign authors. There are now a number of international treaties that require all the signatories, both the US and India are signatories, to protect foreign works. It includes movies, it includes music. Now, music's protected a little differently around the world. In the US, we have separate copyrights for the composition, that is whoever wrote the song, and then we have a separate copyright that's called the musical work copyright, and then we have a separate copyright in the sound recording, a particular artist's rendition of the song. Sound recordings of that particular artist's rendition treated differently around the world a little bit, but still get some protection. Generally, facts are not protected. This is a white pages, and so the individual telephone numbers and their the person who has that telephone number used to be the way you find someone's number, not protected because it's factual information. So that's an important exception in copyright. Just because you're the first to report a fact doesn't mean you get a copyright in it. Okay, so let's think about this. Here are two photos, one by Ron Reisman, one by Eric. Can't quite see it. Eric Gendron. So copyright infringement, do they each get their own copyright? And so you would need to know, did one of these authors copy the others? One of these photographers copy the others? And you can copy it either mechanically, that is, you can just make a digital copy of the JPEG or other type of photo file, or you can copy by reduplicating the photo, right? You saw the photo on the left, Eric did, and so he says, well, I'm going to recreate that. So he goes out and tries to recreate it exactly as possible. Now, in this case, the two photographs were actually taken by the two photographers on the same day. They were about 100 feet apart, maybe 30 meters apart. And they each took their own photograph. And so they're each going to get their own copyright, and neither is going to be an infringer of the other's work. They're both going to be entitled to copyrights in their own work because they did not copy. So they're each original, did not copy, and minimally creative. They selected the camera angle, the subject matter, and so on. And so they're each going to get their own copyright. Now, again, I talked about expression. Copyright only protects your expression. So we can have two plays. Here's a play on the left, Abby's Irish Rose, and a movie on the right. The play eventually became the movie, as you can see here on the screen. Very similar stories. Melting pot, classic story in the United States, right? New York City was a melting pot in the 20s and 30s. We had people from lots of different cultures. The parents often wanted their children to stay with their culture. So in these cases, it was Irish Catholic and a Jewish family living in the same building in New York City. And of course, the son who was Jewish and the daughter who was Irish Catholic married and fell in love. And that was the story in both of these movies. The play came first, Abby's Irish Rose, and she sued when the Coens and the Kellys came out saying that, hey, you took my story. Irish Catholic versus Jewish family in New York. The children fall in love like Romeo and Juliet, except not everyone ends up dead at the end of the day. Sort of a happy ending. The children get married, they have grandkids, and that leads to reconciliation with the parents because they really want to see the grandkids. But the court said no infringement here, right? Didn't take the detailed expression in Abby's Irish Rose, the Coen and the Kellys. If they took it at all, and that was not clear, right? This is the sort of general outline, boy meets girl, boy loses girl, boy gets girl back, that anyone might come up with. And so at that general level, not going to receive a copyright. And copyright does not extend that far. Okay. Now, trademark is completely different. It's very open on subject matter, anything, words, shape of a product, the color of a product. It carries meaning to consumers about who made that product. Unlike the other two where we focused on originality and novelty, here the trademark prerequisites are, have you used it in commerce to identify your goods? Is it distinctive? In the trademark sense, this means, has it come to uniquely identify you with your product to consumers? So Coca-Cola, Budweiser beer, whatever your favorite brands are, and you've associated that with a particular company. You expect certain characteristics when you buy that product, and that makes it a trademark. And then it has to be non-functional as well. The infringement standard here is, again, are they too similar so that consumers are likely to be confused? They're likely to be tricked into buying the defendant's product thinking they're getting the plaintiff. Unlike the first two, which had limited times, though copyright was a very long limited time, trademarks last until they're abandoned, that is, the owner stops using them, or if they become the generic name for the product at issue. So here are some trademarks. The Apple trademark on the left. That's a classic symbol. The Coca-Cola, the shape of the bottle, the red and white color pattern or design on the label, things of that sort. And even the shape, this is a igloo-shaped doghouse, as you can see. And so the shape as well as the name Doggloo are all trademarks. Now again, you can't protect it as a trademark if it's the generic name for the product at issue or if it's functional. So Miller tried to, in the United States, sued and tried to obtain the exclusive right as a trademark to use the word light for beer. And the court said, no, that's a specific category of beer, low calorie beer, and light is the common name for it. So we're not going to give one manufacturer the exclusive right to call their beer light. Another company here on the right, they had a utility patent, but again, those expire after 20 years on this dual spring design for road caution signs. What it does is it allows the sign to blow down in the wind, and then when the wind passes, the sign springs back up as opposed to just getting blown down the road. So when the utility patent expired and someone copied that dual spring design, the company tried to claim that that's their trademark, trade dress, it's sometimes called, the design or dress of the product. And consumers had come to associate those dual springs exclusively with them and their high quality products. And the court said, no, you can't get a trade. You had your utility patent. We're not going to give you perpetual protection under trademark law for that same feature. It's functional. It's the reason the sign works. And trademark is not about patent or copyright providing you with a monopoly. It's about helping consumers figure out which product they're buying when they're sort of buying a product. So put a label on it, but we're not going to give you the exclusive right to sell these dual spring designs. Just identify your product by some other means, your brand. Okay, so that brings us to the last of the 4 statutory areas, and this is trade secret. So trade secrets are information that is secret and valuable because it gives you a competitive advantage. When I talk to my clients about this, this is just generally stuff you don't want your competitors to know. It could be anything. It could be customer list, could be your bid you're submitting on a government project. Obviously, you don't want your competitor to know that, or they'll submit one for $10 less. It could be the formula for Coca-Cola. And in the US, we also require you to undertake reasonable efforts to maintain the secrecy of that information. Maybe this means guards, limits on access, only those who need to know it get access to the Coca-Cola formula, non-disclosure agreements, NDAs, or confidentiality agreements with your employees and anyone else who's given access to the secret. So if you want us to protect it legally, you got to take some steps to protect it as well, so you're not always running into court. And if it becomes public information and everybody can find it out on their own, then it's no longer a trade secret. Now again, doesn't require true secrecy, only reasonably secret. And so I always joke with my students about this. You know, how many people can know information and still be secret? And the answer, of course, is 2 if one of them is dead. So we don't require true secrecy, because if it was truly a secret, only you knew it, you would never have to sue anyone else over it. But this is information you're going to use in your business. You may have to disclose it to some employees so you can exploit it efficiently or produce the product you're trying to sell. So other people are going to know your secret. And so it has to be reasonably secret, not true secret. Now, it only protects, if you have a trade secret, against misappropriation. If someone wants to go out and buy your product and figure out what makes it work, how it's put together, that sort of reverse engineering is not sort of within the scope of the trade secret misappropriation. That is legal and legitimate. But if you go and hire a former employee, or you get them to breach the duty of confidence that they signed on to, or you use wiretapping or corporate espionage, sort of improper means to obtain the secret information, then that constitutes misappropriation. And so, of course, reverse engineering very common. When Chrysler first came out with the minivan in the 90s, Ford and a number of other automobile companies went to Chrysler dealers, bought a bunch of the vans, and then took them apart to see how such a popular product was made, and then they tried to copy it as best they could. And that's legal under trade secret law. Once you put that product on the market, others are free to copy it. Okay, so you have these 4 different areas, but of course you're not relegated to just one, right? It's not, you only get one and no other. You can pick as many as you want, and sometimes to protect effectively your product, you may have to combine a number of these different areas, though sometimes there's one or more that makes the most sense. So if you've come up with this jack-o'-lantern trash bag idea, what sort of IP are you going to use? Now, obviously, trade secret's not going to work, because as soon as you put this on the market, everybody can see exactly what it is you're offering, and they can just reverse engineer by buying your product on the open market. Copyright, you might think it's an artistic design. You probably could get a copyright on that. But keep in mind, copyright provides narrow protection. That is, it only protects against copying. So if someone does their own jack-o'-lantern trash bag with a slightly different facial appearance, then you're not going to be able to sue them for copyright infringement. And it only protects your expression, not your idea, not the idea of a jack-o'-lantern trash bag. So if they want to do their own version of it, that is not going to be copyright infringement. You might be able to claim it as a trademark, though here it's a little troubling. First problem is that to become distinctive, you have to sell enough of these trash bags so people start to identify it with you uniquely. So it may take some time to develop that distinctiveness, and that may give your competitors a window to jump in. And then the second problem is that this is also the function, right? The whole point of the trash bag is to look like a jack-o'-lantern. So court may be unwilling to give you a trademark or trade dress in what's really the principal feature of the product. That leaves you with patent. Now, utility patent probably out. This doesn't hold leaves any better than existing patents. Doesn't even, existing trash bags, doesn't even do the job any differently. But there's also in the US a design patent, and industrial designs are protected in different ways around the world. In the US, we do them through a design patent. This is for the non-useful ornamental features of chairs and tables and any sort of industrial product. And so the inventor here actually got a design patent on the jack-o'-lantern trash bag. And so was able to maintain exclusivity in the market. Didn't hold up over the long term, but they got at least the first 2 or 3 seasons under their belt. And that gave them a real window in which to recoup their investments. What about the perfect opener? Well, you can see you got the trademark there at the top, the words perfect opener. They've got the little TM up there next to perfect. In the US, we either put TM or R in a circle. If you've obtained a federal registration, which is not a prerequisite for trademark protection, but really helps you out in terms of some of the procedural aspects of it, you can use the R in the circle. If you don't have a federal registration, you probably don't have a trademark, so you put the TM. And saying, I wish I had a trademark. But you might be able to get, again, copyright, not going to be much help. Trade secret, not going to be much help. You got a trademark on that, but people could change it pretty readily. So you're going to have to use a combination of design and utility patents here to protect your product from imitation. And they're not going to do the job perfectly. Often the best sort of IP protection is not a legal protection. It's just doing the best job, getting your product out there first and best and at a good, fair price. And then consumers become loyal to you. And so probably here design and utility patents, utility on the combination of features into one particular product, and a design patent on the shape of the opener, the pill caddy. There are also in the US a few miscellaneous doctrine. I'm not going to go through them. The last one I should mention expressly here, the non-disclosure agreements and covenants not to compete. These are essentially just contracts. They're not really IP because you don't enter into them with the world. You can only enter into contracts with specific people, but you can get your employees to promise not to compete with you or not to disclose your confidential or proprietary information. So contracts are a very flexible device in which you can use on a one-on-one or one-on-a-few basis, but a negotiated basis to get people to agree not to take, or if they do take, compensate you for use of your idea. Okay, so that's all I have. Now I see we have a few questions in the question and answer.
Thank you, sir. It was very, very enlightening and insightful presentation. So if you allow, can we have few questions?
Sure.
We can limit it to 4 and 5 questions. Starting with Shagun Goel. So Shagun is asking, so can monopoly affect or somewhere influence the laws of IP?
So I'm not sure exactly what he's asking by this question. So if you're a copyright or patent holder, you don't like the term monopoly, and indeed some of the courts here in the US have prohibited attorneys from referring to patents as a monopoly. I'm just referring to them that way in terms of if it's effective, the whole point of a patent is to exclude competitors and allow you to raise your prices. Now we can pretend that's just property, but it's really a monopoly in economic terms. Whether it's a good or bad monopoly is a different issue. But certainly there are areas where antitrust law and anti-monopoly concerns come in and play a real role in influencing the shape of IP law. So let's say I have a patent on my pharmaceutical and you're a generic manufacturer and you think my patent's invalid. So you start selling a generic product and then I sue you. And so then you say, well, I'll give up my lawsuit if you pay me off. And so there you're using the settlement agreement and the patent as a way of preventing challenges to your patent. But there are real monopoly concerns there, and the courts have recognized those in that category of cases.
Thank you, sir. So we have another question. Please give a brief idea about non-functionality prerequisites in trademark and difference between a trademark and design.
So trademark protection, what we're really talking about here is trade dress protection. The dress, the design, the appearance, the packaging of the product is potentially perpetual, never expires. So if I could get a patent on something or trade dress on something, if it's functional, if it's the reason the product works, if it's sort of the dual spring design that holds the sign up, we want you to go into the patent system. That's well designed for that sort of technological advance. The prerequisites, are you entitled to a patent on it? The scope of that patent, make, use, or sell according to the claim language, and the duration are all well tailored, we think, to give you a good incentive to get the right amount of inventive output. If we're going to give you a perpetual trademark on that, that may really skew the incentive calculus, and now you have a perpetual monopoly. So if something's functional and it should have been patented, we're not going to give you protection, perpetual protection as a trade dress. And that's been given on any number, litigated on any number of issues. For example, we have a cereal in the US, shredded wheat cereal, where the shredded wheat is shaped in a little pillow biscuit form. And someone tried to claim that they had patents on that initially, but when they expired, Nabisco said, well, we want a trade dress or trademark on the shape of the shredded wheat biscuit, so only we can make it in perpetuity. And of course, the court struck that down. And so in the US, we get Nabisco has their shredded wheat, Kellogg's has theirs. There are lots of store brands. And so consumers get the benefit of that competition. Nabisco, National Biscuit Company at the time, got the patent monopoly, and so it was exclusive for, I think, 15 or 20 years. But that was enough of a reward for giving us that cereal. After that, they just had to compete with everyone else.
Thank you. Thank you, sir. Another question is, sir, can you please introduce us to related rights?
So in the US, we don't have related rights, but related rights are in the copyright space. So I talked about musical works, the composition of a song, and the sound recording, a particular artist's rendition of a song. In the US, we treat them both as copyrights, though we treat the sound recording copyright quite differently than we do the musical work copyright. But in most of the world, sound recordings are relegated to the status of related rights. Industrial designs are often put into related rights. These are things that are like copyright, but are not going to receive the full scope of copyright protection, not the full duration, not the full breadth. And so it varies a little bit in each country as to what's in copyright and what's in a related right. As I said, in the US, we don't have related rights. You're either in copyright or you're not.
Okay, thank you, sir. There is another question. It is regarding the Coca-Cola case. An employee of them agreed to share the formula with Pepsi, and when Pepsi got to know when the company informed Coca-Cola, then in that case, which case can Coca-Cola file on his employee?
So the advantage of trade secret law is it extends the reach of the trade secret holder beyond contract.
Okay.
So contract would give Coca-Cola the right to sue the employee who breached the contract.
Okay.
But that's not really an effective remedy. That employee is not going to have the assets to compensate Coca-Cola for the harm done. Pepsi was not a party to the contract, so the contract doesn't bind Pepsi. Now, you might get a third-party inducement to breach theory in some states and in some countries, but trade secret does that directly. If Pepsi went in and paid an employee to knowingly divulge secret information, then trade secret law entitles Coca-Cola to go after both Pepsi and the employee who divulged the information. And so Coca-Cola could go after the employee for breach of contract and for trade secret violation, and could go after Pepsi as well as the knowing recipient of that trade secret information.
Okay, thank you, sir. Sir, we'll take one last question, and if you allow, we can take a few more if you allow. Otherwise, sure. This will be the last question. So how Vaishnavi has asked, how has the internet impacted IPR? Is it possible to list the main broad aspects?
So not much change in the patent space, maybe a little bit. The big changes have been in copyright and trademark. So let's take copyright to begin with. There's a lot of unauthorized copying going on the internet of copyrighted works of authorship, file sharing of music and videos. There are places you can go and obtain file copies of books in digital format. The rules, the law is still in some sense the same, but practically it's very difficult to enforce your copyrights on the internet, right? You shut down 3 sources of pirated copies and 3 more sort of pop up somewhere else. So the copyright owners are always looking for a way to put the genie back in the bottle, as it were. Can we hold Google responsible or other platforms that enable these types of piracy or copyright infringement to go on? Can we hold the credit card companies? Can we make them the internet police? Because a lot of those pirate sites have to find some way to monetize themselves, hold the advertisers or the credit card companies responsible for policing against those types of infringement. And the European Union recently adopted some legislation trying to deal with some of that. We'll see how well it works or doesn't work. But nothing has really stopped it so far, except copyright owners making their works available in a convenient form at a reasonable price.
Okay.
And so the advent in the United States, for example, of Netflix as an avenue to get lots of entertainment really sort of slowed, and Apple iTunes, and now streaming services. I mean, who would file share music anymore? I can join Spotify or Pandora or one of the other services and get all the music I want. And I don't even I can get it on an advertising basis, pay nothing, or I can pay $10 a month and get all the music I want. So we'll see how that turns out, but they haven't found a legal trick that enables them to really effectively shut that down. They spent a lot of time and money suing people.
True.
But it was really making their works available in a convenient way at a reasonable price that really made people shift from piracy over into legitimate channels. We'll see what happens in the US. One of the problems we're having now is we're getting the redivision. Now you have to join not only Netflix, but Amazon Prime and Hulu, and now you got Disney Plus and HBO Max, and you got 12 streaming services you now have to join if you want to get the full range of content, and that may push people a little more back into the piracy option.
Right, sir.
As for trademark, right, the big problem there is originally it was cyber squatting. I'd take your famous trademark and I'd register the domain name for it because you were slow to recognize the benefits of internet. And so some of it was kind of clever, and some of it they would set, one guy registered 𝗕𝘀𝗶𝗵𝗀𝗍 and he sold it to Pepsi, who was the owner of Taco Bell at the time, for a year's supply of Taco Bell. And so some of that went on. That's largely gone away. Now the problems with the internet is people registering domain names very close to legitimate sites for banks and credit cards and other sort of services. and then trying to set up phishing sites to get you to put in your password and your user ID so they can steal all your money. And that's not really a trademark issue. It's just a cybersecurity privacy issue, but you could come at it, and sometimes I do, through the tools we gave for trademark, because again, often if it's Chase is your bank, JP Morgan Chase, they'll register something very close to chase.com.
Oh, okay.
And so still have those issues going on in the internet.
Right. So we have another question, since you are being kind enough to take a few other questions. So Rupali has a question. If you can brief us about how to go for a research in patentability in medical procedure.
So medical procedures, the rules differ quite a bit from state to state, from nation to nation. In the US, you can get a patent on it, a surgical procedure, for example, but then the statute also provides that they're not enforceable against a doctor who undertakes the medical procedure. So in some of these areas, right, the basic structure of patent law is we give you this exclusive right, it gives you the incentive so you can charge more. Well, you can charge more and that becomes the incentive. We're not as comfortable with people being able to charge more for life-saving things, right? So when the AIDS medications came out and various other life-saving devices, medical procedures came out, we're less comfortable with that trade-off, because if the price is high, you have what economists call deadweight losses, consumers who can't afford that very high price. But that's always bad. But in pharmaceuticals and medical procedures, deadweight loss becomes sometimes, unfortunately, literal, right? People die because they can't get access to the medicine because it's priced too high. And so countries vary quite a bit, and you're just gonna have to go through the statutes and the rules and maybe talk to practitioners in each of the countries to figure out whether research on medical procedures, if it's going to be protected at all, and if so, what the limits of that protection are going to be.
Okay.
India was one of the last holdouts on protecting pharmaceuticals generally, because exactly these sorts of concerns.
Okay. So one last question, and after that we'll wrap the session. What are the steps to maintain a trademark once it is filed?
So it varies a little bit country by country. Again, in the US, registration is entirely optional as long as you are using your mark in commerce to sell goods to consumers. You have a valid trademark. The registration at the federal level gives you certain procedural advantages, different courts you can go into, different remedies that might be available, presumptions of validity. In the US, you register it initially, it goes through an examination process. Once it issues, then you have to renew it every so often. In the US, it's every 10 years, except for the first time. Then it's after the 5th year. And so a lot of people get caught up in that. But the precise rules for maintaining a registration are going to vary a little bit nation to nation, whether it's going to be a 5 or 10 or 20-year renewal time. But most of the nations require you to renew your registration periodically.
Okay. Thank you, sir. Thank you for joining us today and for this insightful presentation and answering to all our questions. It was really, really nice to have you with us.
It was my pleasure.
Thank you, sir. Thank you. Thank you, everyone. Thank you for joining us, and we'll see you in the next session. Thank you.
All right.
Good night, everyone. Thank you, sir. Thanks once again.
Thank you.